Hello, everyone, and welcome to the live webinar version of the Roundtable that the Islamic Law Blog conducted on Islamic legal history and historiography. I'm Intisar Rabb. I'm a professor at Harvard Law School and in the Harvard History Department, and I am here with my colleague.
Hi, Mariam Sheibani. I'm an assistant professor at the University of Toronto, Scarborough campus, and the lead editor for the Islamic Law Blog.
And so we'd first like to just welcome everyone to the session. We have a really stellar collection of scholars who participated in the blog itself, in contributing posts to the blog, and many of whom are here with us today. And so we're excited to tell you a little bit about why and how we convene the idea for the blog. We'll tell you a little bit about how today's session will go, and then we'll just launch right into it.
So a little bit about the genesis of the Roundtable. At the Islamic Law Blog, every semester or so, we convene a roundtable. Last year, you might have seen the roundtable about the translation of the Muwatta, as well as another roundtable on contagion in Islamic history and Islamic law. The genesis for this particular roundtable was a number of different kind of factors that came together. One of them was some of our monthly bloggers. Every month we have a guest editor, a guest blogger. Several of them wrote posts that were interested in these larger questions of Islamic legal historiography and Islamic legal history, Islamic law. And so we thought, rather than posting them as discrete posts within their series, the month in which they were blogging, that we'd gather them and invite other scholars, not only legal historians and scholars of Islamic law, but also Islamic historians of Islamic history more broadly, who touch on law or who are interested in legal and social history more broadly. As well as another kind of development in the field is the publication of several edited volumes in the past few years, the Oxford Handbook of Islamic Law, another one by Ashgate, and other edited volumes. So we thought it would make for a more generative discussion on the state of the field, initially planned as a series of online posts, but in this COVID era, we also thought that convening a live roundtable or webinar would be of interest. So the way that the webinar will proceed today is we have 3 panels. You can see them listed on the topmost post on the blog itself, entitled Panel View. So each panel will invite several of our contributors to discuss some of the larger themes and topics that are of shared interest to them. Each of the panels will last for about 25 to 30 minutes. And at the end of each panel, we'll also invite the other panelists who are not on that particular panel, other contributors, to weigh in or to comment on the discussions. And finally, if you have any questions, you're welcome to share them in the chat. We'll monitor that, and as time permits, we'll integrate them into the discussion.
And I'll just add to that one of the other motivators was that there were many new developments in the writings in the field itself, new handbooks, new questions being asked about Islamic law. And we were thinking about how can we engage scholars who are the ones writing in this field in a way that's more accessible to a wider range of people while not diluting the strength and nuance of the discussion. So we were really pleased that so many of you participated both in contributing to the blog and in reading it. Something like 60,000 readers logged on over the course of the past 3 months to read these posts, sometimes 1,000 per day. and there was more engagement on Facebook, Twitter, and other fora. So it ended up being a really fun thing to do, I think a generative thing to do, as Mariam pointed to. And it was a great pleasure to work with Mariam Sheibani in co-editing, co-convening this series. And so before we begin with the first session, I just want to thank her and all of you who contributed, all of you who contributed through reading, and Omar Abdul Ghaffar, who is a PhD student here at Harvard, who conducted 2 of the interviews, Jem Tejamer, who is an SJD student at Harvard, or an SJD candidate at Harvard, who also edited the posts, Anne Brown, our program coordinator, for helping bring us all together, Ibtisam Saleh, who is a student editor who helped generate some of the social media posts, and faculty and historians, law professors and students from here at Harvard and from other institutions who helped contribute to some of the post contributions, ideas throughout this 3-month span. So with that, I'll go ahead and launch into the first session. And for those of you who are answering questions, please unmute yourselves and feel free to jump in. On this first panel, we've called it Social Historical Studies, Legal Texts as Sources. It's one of the themes that we saw arise out of some of the posts, and we gathered together these 6 scholars around that theme. Michael Cook is the 1943 University Professor of Near Eastern Studies who wrote on simplicity, creativity, and lucidity as method, which has to be in quotes because he can say more. I don't think he believes in methodology per se in the study of Islamic history, which was an interview that I conducted with him in January. Najm Haidar is a professor at Barnard College who wrote on future avenues in the study of Islam in December. Carl Petrie is a professor at Northwestern University who wrote on crime during the Mamluk period and the study of legal history in January. Joseph Rappaport is a professor at Queen Mary University of London, and he wrote on studying a lived law. This was an interview conducted by Omar Abdul Ghaffar in January. The 5th scholar is Marina Rustow. She's a professor of Jewish civilization in the Near East and of Near Eastern Studies and History at Princeton University. She wrote on Islamic law and the documentary record before 1500, Unsolved Problems and Untried Solutions in January. And last but not least, Elizabeth Urban, who is an assistant professor at Westchester University of Pennsylvania, who wrote on 4 historical strategies for approaching early Islamic law in December. So to start out with, I'll ask a question to Marina Rustow, Carl Petrie, and Michael Cook. Questions about the sources. So you all use a mix of sources, documentary sources, literary sources, and you speak at length about them in your posts. Do you use them all equally for the areas that you, or the areas of historical inquiry that you focus on? Or would you say that some sources are better suited for different queries? Marina, would you like to take it first?
Sure. So I primarily use documentary sources, and I've gone on public record as saying that I try not to read any text of more than 1 page if I can avoid it. But the fact is that's not true. I do occasionally have to read long form texts. And, you know, the funny thing is, so my first project, which was on the politics of the Jewish community under the Fatimids, like the whole entire project was about demonstrating that the literary sources were misleading, that all we had in terms of Jewish communal politics, and especially the Karaites and the Rabbinites, was a record of polemic. And that when you got into the documentary sources, things were much more complex. But I found actually that in my more recent work, when I've been trying to work on state documents, the literary sources have been enormously helpful, to the point where I find myself actually going in the other direction, wanting to believe every single thing they say. So I think it's a constant struggle to try and bring the two types of sources together.
Great. Professor Petri.
In terms of sources, of course, the narrative sources, often referred to as chronicles, and actually to this group here, they're very widely known. The Mamluk period produced an enormous number of them. Some of you may be, I think most of you may be familiar with the study at Ghent University that Jovan Steenbergen presided over, and that they've identified, they're digitalizing many of these. And I noticed in some of the material for this session, the issue that Michael Cook brought it up, the issue of digitalizing raises questions about consulting, but they are doing remarkable things. But it's an enormous amount of material there. And I mentioned in my piece that a very high percentage of the people who wrote them had some involvement with the law and its application. Many of them were practicing qadis themselves, and they wrote on the side. And certainly the most famous of them, people like Ibn Khaldun and Makrizi, and that they were qadis at some point in their career. And therefore, they much of the material that they lifted, that you were able to see the actual process of litigation playing out in these sources. I would say for the other very important sources for legal interpretation are the endowment deeds, many of which have been the Waqf al-Awqaf, which have survived from the Mamluk period. Actually, I imagine that they are the largest in Egypt, certainly. I've never had a chance to consult them in Syria. But in Egypt, it's the largest group of these before the Ottoman period. Relatively few of them have survived in the Ayyubid and Fatimid period, and virtually none earlier than that. But for the Mamluk period, there are hundreds and hundreds, and there's been a fair amount. Some of these have been cataloged. Muhammad Amin, his catalog that he published years and years ago with the French Institute. So those really are the sources that I've personally worked with.
Professor Cook, you famously work with all sources and have your students do the same. Can you speak to this question?
Well, I suppose I could, but I don't have a whole lot to say about it, because well, thank you, by the way, for not asking me a question about the history of Islamic law specifically. You made it nice and general. But I mean, it seems to me that yeah, what you do is you go to the kind of sources that you think are likely to answer your question. And of course, what tends to make it last a long time, the whole process, is you often make mistakes. You think you're going to find an answer in that kind of source, and you don't. And it's actually just waiting for you in some other kind of source you didn't think of. But that's all the sort of give and take of research.
Great. I will go on to another question having to do with a popular theme across the sources, and it's something that I noted in the concluding post to this roundtable, that a number of the scholars here said, well, I'm not a legal historian, I'm a social historian. And some of that is part of the point of why we combined this set of historians of all types, but who work on law or legal history, legal and social history as broadly construed. But I would love to hear from you all and some of those who said it, whether or what disciplinary differences you may see in approaching the sources, really with an emphasis on social legal historian. Professor Haider, can I start with you?
You can start with me. Yeah, I mean, you asked that question, and it was I never actually see myself as a legal historian, but I mean, I think that, you know, building off of what Carl said a few minutes ago, I mean, a lot of these scholars wear multiple hats, and a lot of the material that actually survives has a sort of a legal bent. And so, I mean, I think at least in the early period, you just go with what you have, and you don't have very much. I mean, I'm jealous of the hundreds of chronicles that or literary sources that people would have in the Mamluk period. We have so few in the early period that you can't really pick and choose. So you take the material that you have and you do with it what you can. So I think in early Islam in particular, the key becomes finding a way to work through the sources, finding the right methods, with apologies to Michael Cook, to apply to the source material to get the information you need. So once you get to the early period, I think we're all legal historians, but we're also all social historians, and I mean, everything is so mixed together, and that doesn't even begin to get to the question of what disciplinary boundaries meant at that period at all. I mean, who knows what the world looked like and what the categories were in that earliest period. So it just all gets so muddled together in the early period that I can understand why so many scholars begin in the early period and then they're just like, I'm done. Send me to the Mamluks. The Mamluks have stuff that we can look at.
I'll ask another scholar of the early period, Professor Urban.
Thank you for this question. It's something that I noticed too when I was looking at the other blog posts, is several people saying, no, I'm not a legal historian, I'm a social historian. And I can only speak for myself when I say that. I think another theme that came up was the issue of specialization versus kind of being able to have these interdisciplinary conversations, and how to manage both having to master certain subdisciplines, how to read papyri, feeling like you need a JD in order to understand the kind of theoretical concepts behind the law. And so I certainly feel like sometimes there's an expectation that we have to be a specialist and perfectly understand everything. I know, speak for myself as a bit of a perfectionist, before we can even begin to say anything. And so this kind of tendency to say, well, now look, I'm not a legal scholar. I think trying to avoid coming across as knowing more than we do, especially about an early period that is, I think, characterized by debate, contestation, fluidity, all mixed together, as Professor Hyder has said. So yeah, I really needed to kind of view the entire early period, maybe trying to let go of the sense of needing to be a specialist in any one particular thread in order to be able to delve into this period that is specifically characterized by divergence and debate. Something that Professor Cook had said in his interview was something like, would you rather be remembered as a philologist or as a historian? And kind of, I'd like to be remembered as kind of a medium level of both, and not a super specialist in either. And that's kind of how I feel like in the early period, you kind of have to be well, I do some philology and some law and some social history, and kind of being okay with the fact that you're not able to specialize terribly deeply in any one of these fields because of the nature of early Islamic history.
Great. So the Dunder Mifflin approach to Islamic legal history, since that was an office reference. Then since we've talked about early history, and Professor Hayder says, take me to the Mamluks, let's go to Professor Rappaport for how you might approach this question.
Thank you very much. Actually, during these comments, it occurred to me something that was not in my notes for this, which is maybe the problem is that we are still used to think of Islam as guided by law. And Shahab Ahmed did such a wonderful work in, making an eloquent case of why it's not true. And that's why we keep, and I did the same. I also said I'm a social historian, but in fact, maybe it's because we still have this lingering notion that there is the formal theory of law and there's the lived practice, and somehow we don't understand how they fit together, and they can't. We know that the law is very formal and theoretic, and we still have the students coming thinking that everything that happened in pre-colonial times was guided by Islamic law. And then we have the actual evidence from everything, document, chronicle, everything that shows a kind of continuum. So I end up saying, well, I'm not a legal historian, I'm a social historian, because I don't want to broach this bigger question, but maybe because of the wonderful work you've been doing in this roundtable, in all these blogs, reading them, I really think that we have now a field of Islamic legal studies that can really bridge this dichotomy between theory and practice, and really see society and law as something that, you know, is a continuum, is together. It's not separate disciplines. And maybe I should now revise my blog and say, well, it's okay. I can do this and that because they're part of the same thing.
Great. So my final question for you all is really a open-ended sort of catch-all question, because I want to leave time for all of the panelists to ask questions from each other. And that is, do you have general advice for social legal, shall we call them, social legal historians in training? If there's one thing that you wish you could tell your graduate student or law student self when training in this field, what would that be? And if we just go in alphabetical order, I can, again, perhaps start with you, Professor Cook.
Well, right, I think it depends which kind of student you're talking to. There are students who are fundamentally they're born to be social historians, and you have to tell them to get really serious about the law. In Jones Hall, that means going down the corridor, as you very well know. But I mean, there are other people who are born to be legal historians. They are, I understand you guys are obsessed with law. You live it, you dream it, you eat it, you breathe it. And the point I would make there is, please, when you write about it, a lot of the time you're going to be writing above the heads of someone like me. But please, if you have an interesting social sort of inference from what you're working on, highlight it, put it there where we'll find it.
Great. I recall my time at Princeton shuttling between the offices, shuttling between the offices of Hussein Modarisi and Michael Cook in Jones Hall. That's the going down the hall reference. Another Princetonian, there seem to be quite a few here actually, Professor Haider.
Yeah, I recall going down that hallway too and feeling utterly inadequate in both offices. But I would say that the two pieces of advice I would give, and I do give, the first is to figure out what questions you're interested in before trying to answer them. I mean, I think a lot of times the students don't understand what the right questions to ask are. And the second would just be, don't assume you understand what these genres are. So start from the assumption of treating these texts on the basis of themselves, like let them tell you what they're about. And I think that we impose categories that I think are sometimes misleading.
Great, Professor Petri.
Yeah, well, thinking back on what Michael was saying and this issue and others have been saying, that article that I referred to in my piece that Ronald Jennings wrote years and years ago in Jesho, and terrible loss to the field that he's no longer with us, but he went through those the archives, the Hanafi archives in Kayseri. There are thousands of cases. And I wait for my students when they're reading this, and professor, they never reference Sharia. They someone comes in and these people see, maybe 100 people a day, and you're like, my husband's beating me up or something like that, or someone's walked out and they have my property, and this person reaches a judgment. And this issue that Joseph mentioned, that we're looking at saturation. I mean, these people, they're practical people. It's basically good old ijtihad. They have to reach a judgment, and they do, and everything. But it was striking in all those thousands of cases that Jennings brought up. Hardly any ever formally referred to the procedure that we all knew. You start out with the Quran, and then into the Hadith, and then into the comparison, and then finally the ijma, the judgment. But there it was, and so I often think about that when we think about what was really happening on the ground, even in people who practice the law. How deeply steeped was this in the formal structure that we presume they all knew. They all got that in their madrasa education, but it's something to think about. Definitely. Later on, I'd like to talk a bit maybe in the group, this whole issue because we're living in a time when there's so much sensitivity to racial issues and matters of color. And for many of us, people are just really starting to look at the richness of the sources, but I think they're big interpretive problems. And I really appreciate some other feedback from this group on that matter. Thanks so much.
Thank you. And you talk about that latter issue in your most recent book, The Criminal Underworld in a Medieval Islamic Society, which I have here.
Oh my gosh.
Because I'm working on something similar, so I'd commend that to everyone for reading. And I'll just say something very briefly here, is that I think this is, a really fascinating question to ask. What do we expect from judges? I was actually pretty surprised myself when I first observed some district court judges in district courts in the federal system in America. There are very few references to the formal statute, the law. We don't presume that they're not following those, the proper procedures, but there just isn't time to sort of go through the entire process out loud, or even in a written opinion, contrary to appellate courts where you do see the formal process written. Great, Professor Rappaport.
Yeah, I think what I would recommend when reading a legal treatise or a fatwa, to see that as a social act. Why is the jurist writing this? This is not just an intellectual process. Of course, it's also an intellectual process, but a jurist is writing this for a reason. He wants to achieve a goal, and it could be a personal goal, his own gain, but often I would believe this is a broader social goal, and this and the political, social, economic context of legal writings has to be imagined when reading a legal text like that.
Great, thank you. Professor Rustal.
I was going to say something very similar to Yossi, which is use all parts of the animal. So, don't just kind of recover these amazing gems of stories and narratives, but also think about what was the author doing in writing this? What was the process of writing of the social act? But the other thing I wanted to say is, I think there's a tendency when we're all being socialized into the field, in a way, not to really question the work of the prestigious elders. And something I've come to realize recently is, when it comes to procedure and kind of what's going on the minute-to-minute level, either in medieval Jewish courts or Islamic courts, I don't think anyone really had any idea what was going on. But there's this kind of, like Goitein, I talk about this in my piece, how Goitein writes about what's happening in Jewish courts with such confidence that you think like, oh, he must know something that I don't. And 25 years later, I'm still trying to understand why he said what he said. I don't see it in the sources. So I guess, as philologists, we all have to be socialized, and we all have to sort of, learn from those who have much more experience reading text than we do. But I think sometimes there are kind of these assumptions that get embedded, these kind of phantom institutions or processes that people before us took for granted that maybe just aren't there. So if you don't see it, like, it's like if you don't see something, say something.
Nice. Professor Urban.
Yeah, I think the advice I would give to my graduate school self or to a graduate student would be something along the lines of know your strengths and weaknesses and really embrace your strengths and go with them. And then to address your weaknesses, be in conversation with others. It kind of echoes that that Professor Cook was saying, that for example, I think of myself as someone who's good at seeing connections that other people haven't seen, but maybe I'm not great at, let's say, reading the documentary sources or delving deep into early Shi'i law or something. So be in conversation with people who have those strengths, but embrace your own strengths and don't try to maybe overcompensate for them. Just be in conversation like this. And as Professor Cook said, one of the ways to communicate your ideas and to be in community is to write well and to write in an accessible way and to make your ideas accessible to others.
Great. So that gives us about 10 minutes or so on the broad panel to ask questions of your colleagues. Are there any in the offing? Professor Cook, you are on mute.
Am I now unmuted?
Yes.
Good. Okay, right. So, I mean, I guess there's three kinds of Muslim law. There's Sharia, there's state law, and there's customary law. And of those three, the one we know least about is customary law, right, before modern times. And that has a lot to do with the fact that our sources have an intensely urban bias. Now, the documents we're mostly talking about come from Egypt, and they have a very strongly rural bias. So the question I'd like to put to Yossi and Marina, maybe mainly to Yossi, but also to Marina, is, are all those documents ever going to tell us anything about customary law? Or as Yossi called it, I think in the piece he contributed, tribal law.
Thanks so much. This is exactly what I wanted to talk about, Michael.
Good.
First, specifically about the documents, Marina will be able perhaps to comment further, but I don't think that there is a customary law there. I don't see it. And in fact, as I suggest, I'm even hypothesizing that there wasn't a concept of customary law, that the idea of customary law does not appear in the early sources, and it only emerges in the later Middle Ages, for reasons that this is too much to speculate, but I don't, for example, I gave the example of the disinheritance of women. Okay, it's a Jahili practice, but nobody says anything about it until the 13th century. And nobody says, well, this is the way a certain tribe does it, until very late on. So I actually think that perhaps following what I said earlier, maybe the idea of customary law is part of our modern dichotomy between law and practice. That in fact, pre-modern legal communities like a tribe or a guild or something. They didn't see themselves as having their own law. They're having a variant of the Sharia in the same way that society as a whole is having a variant of Sharia. The state has a variant of Sharia, and so on. So I'm still exploring this, but I really don't see in early sources a concept of a tribal or customary law. There are customs, and this is something else, that are valorized by later jurists. But it's not the same as a tribal, a legal community. I'll stop here.
Great, others?
I can just add to that, in terms of the urban-rural dichotomy, which is it's a fascinating question in general, I think, studying any pre-modern culture, but with regard to the documents in particular, it's true that our documents are by and large rural up until a certain point. After about 950, 1000, they're overwhelmingly urban. And you can kind of get these glimpses of the countryside, but it's always through a kind of urban lens, to the extent that they're in communication with the capital. I mean, there are even documents from the Fatimid period that were found at Oxyrhynchus and Bahnasa, and even those appear to be operating in this same kind of basically urban sphere. So, cities are, I think, just have much more magnetic pull in Egypt once there's an actual capital there. And that's, it's wonderful because you can do certain kinds of comparisons, but it makes comparing also very difficult because they're largely rural before then.
Great. And Marina, did you have a question as well? I think
I wanted to raise this question that Yossi raised both now and also in his piece, because I think about this a lot, which is the extent to which we're all kind of a bit intimidated by law and think that there's something kind of solid and bedrock about it. And part of the reason that I'm interested in this question is that the exact same thing is true in Jewish studies, where somehow people who study the kind of, hardcore workings of halakha are considered to be like on some kind of an exalted plane because they're getting at something that's truer. And, if you ask people about it, of course, they know that that's not true, but there's still this kind of intimidation. And I think there are actually different ideologies, but in the Islamic law case and the Jewish law case. With Jewish law, I think it has to do with, if you had a yeshiva education, you're presumed, and thus know about the law from the inside, you're presumed to have kind of greater access to it. But I think there's something a bit different going on with Islamic law, so I'm just curious to hear people comment.
I'll say one thing here. I mean, that's obviously something that I try to break down sitting at the intersection of the two, right? Being in a law school and a history department. But there's this great anecdote that, just to add one more into the mix, that I think it's Professor Stephen Carter in his Emperors of Ocean Park novel, if I have that right. He wrote about this scene where, the law books, and it's deliberately so, they're all of uniform size. They have these beautiful gold bindings on the thick cover of these law books, which is intended to give this impression of authority and the right answer is here, and perhaps this intimidation factor. And I think you talk to any lawyer or law student and you get the exact opposite impression that law is, we try to order things, but we're trying to order the world that's a mess, and we wouldn't need law if everything was in fact orderly and the answers were all there. And I think that same basic insight translates into Islamic law. I know nothing about Jewish law. I presume it would translate in the ways and for the reasons that you've said there as well. But I too would be curious to hear how folks approach the issue or the question. Any takers amongst you? And you should just unmute and speak. See, folks are intimidated by even the question, Marina.
I'll say that I think about this in the context of Shi'i law somewhat, because it is unordered. I mean, there's an order, but there's so much disorder within, and it just seems that oftentimes that disorder is categorized in a way where it's explained away by you almost feel like there's a drive on the part of the authors of these texts to smooth away all of the rough edges. And so, I mean, oftentimes with Shi'i law, it's just like, well, he says A, but he also says not A. Takia. I mean, you find that as being one of the ways in which the order is imposed upon those sources. But I think that dynamic and that tension is certainly there between what the world looks like and sort of an attempt to place a type of categorization over it. And it's certainly true that if we're looking through that finished product, then we see sort of a legal distortion as opposed to a fully realized world. But I mean, I've noticed it most directly when I look at Shi'i law books. But
great. Well, that's a good note to end this panel on, and I'll hand it over to Mariam Sheibani, who will moderate the next panel.
Okay, thank you. So our second panel is entitled Doctrinal Studies, Approaches to Fixed Texts. And we have 6 panelists on this panel. Haidar Hamoudi, Professor of Law and the Vice Dean at the University of Pittsburgh School of Law. And his essay is entitled Islamic Law from the Internal Point of View. Second, Marian Katz, Professor of Middle Eastern and Islamic Studies at NYU. And her essay was entitled Islamic Law, The Neglected History of Furu' and the Pre-Modern Binary. We also have Rabb, Professor of Arabic Studies at the University of Exeter, with his essay entitled Shi'i Law / Islamic Law, Some Category Problems. Sohaira Siddiqui, Associate Professor of Theology at Georgetown University School of Foreign Service in Qatar. And her essay was entitled Rethinking Dichotomies Beyond Continuity and Rupture in Islamic Law in the Colonial Period. Professor Rula Abisab, Professor of Islamic History at McGill University, with her essay Writing Islamic Legal History. And finally, Ercilia Francesca, Associate Professor of Islamic History at the University of Naples, with her essay Tracing the History of Ibadi Law and Jurisprudence, a State of Art. So thank you all of you for your fantastic essays. My first question is that most of you discussed the underuse or neglect of doctrinal or fiqh sources, generally substantive sources in general, or more specifically Shi'i sources, Ibadi sources, Safavid era sources. So I wanted to invite you to comment on why you think this has been the case, why it might still remain the case, and what would you say are some of the challenges, whether ideological or methodological, that scholars and students of Islamic law face when they approach these sources? And how would you suggest that they can overcome these challenges? So let me start with Professor Marian Katz.
So yeah, thank you for that question. At the expense of maybe repeating a little of what was in the essay, I mean, I feel as if I see 2 major dynamics at work in terms of what I perceive as the understudy of furu' texts. And one is just sort of that there are sort of implicit standards of what qualifies as interesting, right? Conflict is interesting, change is interesting, ruptures are interesting, originality is interesting. And on a surface level, your average sort of large compilation of substantive Islamic law just doesn't manifest a lot of those qualities, right? And so I think there is a way in which they can get neglected on that basis. And the other thing I would say is just their sheer voluminousness, right? And I mean, you know, like I don't exclude myself from this dynamic, right? But I mean, you know, say my current book manuscript, it has a lot of sarakhsi in it. But like, I cannot say that I sat down and read the Mabsut from beginning to end, right? I mean, it's incredibly long, right? And I made a, you know, judgment that I thought was reasonable about, you know, sort of how big a chunk of it, you know, how many volumes of it I needed to read to do what I was trying to do. But like, I think that it's a genre of sources that just sort of poses challenges in terms of the amount of time we have and how much sort of yield we expect in terms of, you know, findings that count as interesting per, you know, 100 or 1,000 pages of reading.
Thank you. Rob, can you comment on this?
Yeah, sure. I mean, I think that the way in which we study Furor texts is changing, and you can see that change in the output in the academic field in the last 10, 20 years. Insights of gender studies, post-colonial studies, various different disciplinary insights are changing the way in which we look at Furor texts. And also, I think as a scholarly community, we're also looking to other disciplines beyond Furor texts. And there's very few people that study Furor texts now and think that fiqh is the be-all and end-all of Islamic law. I think that used to be the case, but I don't meet many people that think that way within the field. So I think that we can be really optimistic, if you will, about the new ways in which we can study this. The variety of sources, even within the study of fiqh, seems to be broadening out. I moan a bit in my blog post about how the Shi'i sources have been not counted as part of the narrative. But I'd also point to a few things which are changing about the way in that, a few beacons of light in which the Shi'i sources are incorporated into the narrative. We've still got a long way to go. And I'm sure Ercilia will still say a similar thing about the Ibadi sources. You know, those of us that work on, you know, traditions which are considered not necessarily the mainstream, we always want to fight our corner. And I think that we're gradually beginning to have an impact on the wider field.
Ercilia, can I ask you to comment on this from your work on Ibadi law? I think she might be having some technical difficulties, so I'll come back around. Rula, you comment in your essay about the rich legal sources available for historians of the Safavid period, and yet that there's little interest in them. What's that about? Oh, you're still muted.
Hi, Mariam.
Yes. Okay, let's go to Ercilia. We'll come.
Can you hear me now?
I can hear you. Go ahead.
Okay. So what you have for the Safavid period is that you have really a rich array of sources on the legal and the juristic history. What we do not have, right? We do not have these kinds of court records that the Ottomanists work with, which is really, you know, I'm very envious. We do not have that kind of a register for the qadis that we can use so that we can look at these connections between law and society. But we do have the other legal genres that are extremely rich, quite well developed. And the reason I think you know, that there is no interest, I'm sorry, okay, can you still hear me?
Yes, please carry on.
Okay, so, but the reason I think that there is much less interest in them has to do with some of the ideological aspects surrounding the field of Safavid studies. There is a sense in which you know, the Islamic revolution in Iran, that basically you look back at the Safavid period from the point of the present, and the present being, you know, the 1980s, the Islamic revolution in Iran. And so Safavid studies seem to have been emerging as that space for contesting the revolution. So there is, in a way, that kind of sensibility And you also can see it with the prevalence of the Corbinian teleology about the fact that Islamic law is rigid and Sufism is fluid. And that the idea of Iran is so anchored in both pre-Islamic notions of spirituality and also in Sufi notions, heterodox messianic. So this is why I think, there are few of us who work on the legal sources. That's for sure. But I need to add a point here, if I have time to do that we have been talking about sources and the availability of the sources, and that it's about the sources, but it really is also about how you approach these sources. I could be using the same older sources that others have used before, and I will come up with a completely different study. And this is where I said that after you actually develop your knowledge about how to navigate legal texts, right? Al-Arabiya, thumma al-Arabiya, and then you go to the Lughat al-Fiqh, where raqaba is not raqaba, yad is not yad. After you have mastered all of that, you still have to develop the theoretical and conceptual tools that will allow you at points to understand that the legal aspects of the legal text may not always, they may point to something other than themselves, that there's a wider range of a conversation with other legal texts, but also with a context. So.
Great, thank you. Ursilia, are you with us? If you are, can I ask you to comment also on the use or the underuse of Ibadi texts, legal texts? Okay, well, we will keep you all in suspense about what's happening in the world of Ibadi legal studies until Ursilia is back with us. But let me turn to another question, another theme that was shared among many of the essays in this cluster. So several of our contributors discuss the persistence of outdated frameworks and binaries, pre-modern versus modern, continuity versus rupture, Sunni versus Shiite, even legal historian versus student of law, and lawyers and judges on the other hand. So the persistence of these frameworks continue to, in their words, excessively structure scholarly inquiry, scholarly research. So I wanted to invite you to comment on what are some of the problems with these dichotomies? How do they impede our ability to trace more gradual legal and structural changes in Muslim societies? And how do you or other scholars in the field, how do you seek to challenge and break down these dichotomies? What other alternatives or other alternative frameworks have you developed or do you suggest be used? Let me start with Suhaira Siddiqui.
Thanks. I think that's it's a great question, and what I tried to do in my post is analyze it through the lens of the colonial period. And if I think about kind of Intisar's first question about sources, I think it ties very much into this question about rupture and continuity. Once we kind of think of the colonial period as a period of rupture, then we're not really interested in the sources as much. And even the sources that we look at tend to be a very specific set of sources. So the work that has been done kind of in South Asian Islam during the colonial period tends to focus on kind of the traditional ulama, the fatawa literature, which was very, very voluminous at the time. And it kind of neglects everything else that's going around, especially within the kind of colonial apparatus of judges and lawyers and the texts that they're writing and translating and commenting upon. And so I think once we invoke continuity and rupture, and specifically rupture in the colonial period, we just end up neglecting a whole set of sources, which I think is one big problem. And I think the other main difficulty, and this is something that really overlaps with what Mariam was saying, is that change often happens very gradually in Islamic law, and rupture is an attractive label to put on something, and it makes it a very easy phenomenon to understand. But when we actually kind of remove this idea of rupture and look a bit more closely at what's happening, we actually see that there's very slow change that's taking place. Even something what Professor Rappaport said about this idea of customary law. part of the reason customary law became such an important category in Islamic law was in fact in the colonial period, because it was said there's Islamic law and there's customary law, and we're enshrining customary law as something very distinct. And so I think even many of the categories that we continue to use are coming from a very specific history. And if we don't kind of look at that history a bit more carefully, then I think we're very much at a loss. And so I think both in terms of the sources and in terms of understanding gradual change, it's important to kind of step away from simply thinking about rupture and understanding that rupture and continuity usually go hand in hand.
Marian and Rob, you both kind of comment on a similar, well, Marian, the exact same dichotomy of pre-modern and modern. Would you like to add anything to what Suhaira said?
Just very briefly, I think so often these, super long-term developments are not unidirectional or they're not one unilinear development, and I think it can be very misleading. I mean, sort of these dichotomies where we sort of, I think it can be very useful to think through something to say, okay, what we're seeing in this period is a transition from X to Y, right? But like so often, you can see, that the same, like the longer term development, you can see it going in the other direction. There are other iterations of that, right? And so I think it can be very illusory when we think of these enormously, sort of large scale developments as being, sort of one time structural shifts, right? And, that can obscure a lot.
Great. I want to bring.
Can I just?
Go ahead. Please, Rob.
No, sorry. It was just a very quick question. I mean, we characterized the 19th century and the early 20th century as a time of rapid change in the Islamic legal environment. Was it any more rapid than the 18th century or 17th century? I mean, I was really struck by Mariam's deconstruction of some of these, and also by Suhaira's notion of this idea, questioning this idea of rupture, because I think it gives the idea that change was so much more rapid when Islamic legal systems came into conflict or came into contact with the colonial powers. I don't know whether we can say that, because we don't have the sufficient granular studies of Islamic legal practice in the pre-modern period to be able to say that somehow the modern period was a period of so much more rapid change than previous times.
Thanks, Rob. I want to bring Haidar into this discussion. In your essay, you distinguish between a different dichotomy, a majoritarian legal historians on the one hand, and maybe a minoritarian approach of the internal perspective, as you call it, relying on heart, of lawyers and judges and how they approach the law. So I wanted to ask, do you think that this is changing with the increasing appointments of JD PhDs to law schools, PhDs often from Near East Studies departments or religious studies departments? And how would you suggest that both sides try to bridge this divide?
Well, thanks, Mariam. I really appreciate the opportunity. And I always feel like a bit of the odd man out when I say this. I mean, I do think things change. I mean, I do think in some ways this is sort of inevitable. I mean, ultimately, even JDs, one has to decide whether they're really trying to persuade a court and make the kinds of arguments that persuade a court, or if they're really looking at things from the outside. And I guess what I was really trying to get at in the essay was to say that, a lot of times there isn't as much of a focus within our studies on the internal perspective. And I do think that there's more appreciation for it. I mean, the best example of this is this really interesting focus of, we should be, as Marian says, thinking about the furu'a more. That's all the courts ever, I mean, well, I'm exaggerating. That overwhelmingly, the courts are obsessed with the furu'a. A lot of it is that sort of core diving down into, as she describes in the really interesting piece, diving into one particular issue and sort of diving through. the other issue with questioning the rupture. Again, I just don't think there's the idea of a rupture is of extremely diminished importance to any modern court, which is attempting to approach Islamic law. There's this assumption that there are doctrines. These doctrines are internally stable. They do evolve and manage to contextualize themselves over time, but at the same time, the notion that there is a broad continuity, that the law is able to create its own normative categories, and that one can understand them in what would, from a historian's point of view, surely be a radically decontextualized notion, is one that's very common among courts, and in fact almost has to be assumed in order to make an effective argument before one. So I do think that the increased number of JDs has resulted in a much broader appreciation, and I do hear a lot of that as we occur. But I do emphasize, as we're discussing these things, but I do want to emphasize, it seems to me that ultimately everybody sort of has to decide whether or not they really want to adopt, or what kind of perspective and what kind of assumptions they want to adopt when they come to approach Islamic legal material, and some are going to be different than others.
Fantastic, thank you for those comments. The last question I'll pose to this panel is also kind of similar to Intisar's last question about training graduate students and looking to the future of the field. Many of you mentioned that there's this difficulty or perceived difficulty in reading substantive fiqh or furu' texts. They're too technical, too specialized, too dense, too boring, as Mariam put it, being the main reason, or maybe the primary concern that students have, and the reason they steer clear of them. And this is compounded, of course, for Shiite texts, for Ibadi texts. So my question is, how can we, encourage students to approach these texts intelligently, confidently? How do we train them so that they're prepared for that? And Haidar, how do students of law and law schools that are interested in Islamic law, do they approach these texts, and how do they approach these texts? So let me start with Mariam.
Well, I think the key for me in sort of making this kind of text more engaging for students is just sort of the dialectic between reading really interesting secondary work and reading primary sources, that, you approach the primary sources with, the richest possible set of sort of like questions and perspectives, like in your mind, right? Because the more, sort of questions you have, the more things that you're sort of actively looking for, the more concerns that you have in mind that they may potentially be relevant to, like the more interest they're going to have for you. And I feel that often, like when I was trained, I mean, not to knock it, because I was very fortunate in my training, I feel, but that, reading primary texts and reading secondary scholarship was very separate, and I don't think it should be.
Great. Rula? Still muted.
Yeah. Sure. The way I have approached this question is I have two graduate courses that are hands-on. One is on fiqh al-jihad, where we actually read these texts, but on top of that, I let the students break out into groups where they would prepare different aspects that branch out from the text on, let's say, transmitters of hadith. They will go into the science of hadith. Also, in another course, I do usul al-fiqh, and I conduct it as much as possible in Arabic. And I ask them to direct their questions in Arabic. They can prepare them ahead of time. And in this text, which is no longer even taught at the Hawza, there's a mix of usul al-fiqh and kalam. And again, in that course, they get actually to have a direct training in navigating these texts and understanding them. It may be, it may be a challenge. I mean, you're right. You have students who actually find it very, very difficult. Others who actually get a lot out of it. But I think for fiqh al-jihad, almost everyone would have to be able to find it accessible. Jurisprudence, is more theoretical, and there you may have more, diversity. So, yeah. So this is one of the ways in which I approach this.
Thank you. So what I'm hearing is topics and issues that are of interest to students being a primary gateway. Suhaira?
Yeah, I think for me, the main thing to remember is that texts are dynamic. They're written by individuals, and individuals always have a specific social and historical context that we have to understand. And so I think for students, the more that we can connect the actual text to the social and historical context, I think that matters greatly. And I think also to the extent that we can connect those texts, even though they're in Islamic law, to a lot of other disciplines. And I think this was mentioned in the first panel, is that, you know, scholars are writing in multiple different disciplines. We call it Islamic law, and we kind of put it into these nice little fields and genres, but these texts are actually very much talking to one another. And so I think the more that we can show students that the furu' works are talking to other works, be they of political theory, or be they of usul al-fiqh, be they of, you know, all of these other genres, I think it can make them much more dynamic. And so I think the more that we show the dynamism and the lived reality of these texts, the more interesting they'll become for graduate students to read slowly.
Okay, thank you. Rob?
Yeah, I was just thinking that Sahara said what I wanted to say, but I would say one additional thing is that, you know, to study the development of Islamic law at any one point in time means actually engagement with a multiple range of genres. And I think that in the classroom, what we really want to be able to do is to be able to demonstrate to students that fiqh seems like the natural place to go to study Islamic law, but fiqh happens in relation to lots of other sorts of genres, and that students who want to be able to understand the dynamics of it will need to engage with different types of sources. And I think that if we can instill a little bit of the excitement of being able to triangulate between these different sorts of sources, then I think that we will have a really vibrant generation of Islamic legal scholars.
Great. And last but not least, Haider.
Well, last and least, but that's okay. I'm all the other panelists are so preeminent. Is all I meant. Yeah, I mean, the way that I tend to try to teach these things within law schools, within law school itself, is to start with the material with which they're most familiar, which is contemporary cases. And contemporary cases cite all of the furua texts that we've been discussing across all of these different eras. And interestingly, as I pointed out in my essay, you know, they sort of start at the end. That is to say, the more modern tends to control, because it tends to be more contextual. I mean, talking about context, the answers that modernists provide tend to be a little bit more specific to the fact pattern in question. But what is interesting is they do tend to cite across eras and end up somewhere in foundational text. And it's always useful to me to start with that text, to start with the framework of the court, what it's trying to decide, and then to pull the particular sources that we're talking about, and to get the students to understand what those sources are, what they're trying to say, and sort of piece it together that way. And I realize that's sort of looking in the other direction, but it does help show how modern courts use these furua texts over time, and how they sort of view this idea of legal continuity really from the Quran straight to the present, and the manner in which the psychology of the court in being able to put these together. But I always find it most useful for law students, in particular those who have not had the benefit of a doctorate in another discipline, to start with the material with which they are the most familiar. And those are going to be court cases, or I should say legislation as well, because you get a rather large travaux préparatoires that sort of explains some reasons, and almost always cites fiqh texts as well in that context.
Okay, great, thank you. So that will bring an end to our second panel, and we'll shift over to the third panel. Thank you to our 6 panelists. And now I'll invite our panelists for panel number 3, quantitative methods, computational approaches. We have Metin Kirschgel, professor of economics at the University of Connecticut, Boach Ergini, professor of history at the University of Vermont, Professor Intisar Rabb, professor of law and history at Harvard Law School, and Irene Kirshner, PhD candidate in the Department of Arabic and Islamic Studies at Georgetown University. So thank you, all of you, for your essays. We have, let me just mention the titles of their essays, co-authored by Metin and Boach, Pluralistic Methodologies in Islamic Legal History, Historiography. Professor Rabb's essay, Islamic Legal Canons as Memes, and Irene's essay, Measuring Interpretive Authority, a Methodological Reflection. So the first question I wanted to ask of all of you, for members of the audience who may not be as familiar with this emerging field of Islamic digital history and digital legal studies, what are some of the new initiatives in computational approaches to the study of Islamic history, Islamic law more specifically, if possible, and how have you seen these digital technologies used in effective ways to further the historical and research agendas in Islamic law and legal history? How have you used them in your own work? So let me begin with Boach.
All right, I just unmuted myself. Thanks for this really great panel, and thanks for inviting us to this conversation. I think very briefly, I think we have to distinguish two different approaches, I think very much implicit in the question. We have to differentiate the quantitative approaches, and Metin can talk about that, and also computational approaches. Historians and scholars of law tend to kind of confuse those two approaches. One of them is much older, actually. Professor Jennings's work has been mentioned before by Carl Petrie. He's absolutely right about the fact that Jennings was one of the pioneers in this field. And he did all the time when he was looking at the Ottoman court records, use all these kind of quantitative methods, not particularly sophisticated ones. And Metin can talk about that. But he did absolutely do all that quantitative search and research in 1970s. There is a lot of potential for computational methods. People tend to use computational as a term in place of digital. They are not identical, although they can be replaced. And Irene's essay, to some extent, is about that too. And that is an emerging field. For example, look at all these, semantic analyses of fatwa texts, for example, or making intra-corpus or inter-corpus comparisons by using all these machine reading methodologies. So there's a lot of potential about that. That kind of research has started already in other fields, in Islamic subfields, in Islamic history, and it is, in fact, kind of, making some progress in legal analysis too. For example, there is now research out there looking at all these fatwa, as just mentioned, corpora, and making comparisons by loose machine reading approaches and comparing different themes across these corpora. What kind of themes exist in one corpora, something that cannot be accomplished by individual researchers, and follow the trajectories of change over time. And that can be done by computational research.
Okay, great. Thank you for that distinction. That's very, very helpful. I'll turn to Metin.
Thank you. It's a great question. Maybe I'll make another distinction to talk about the way the greater availability of digital records makes, and that's one in the area of data collection. So we have all of a sudden in our hands a lot of books and a lot of court cases. For example, the Istanbul Sigilleri project, for example, is one of them. There are hundreds of them, and there are more in the works. Whereas only 10 years ago, Boach spent a lot of time copying things and records and trying to digitize them. Now it's been done and made publicly available for everyone. In 2 clicks, you can access a lot of digital records. The other area, this is probably where I come in, is in terms of the analysis of these. The more these records are digitized, the more they become amenable to analysis by people like myself, who are economists or other social scientists. Economics, as you know, is more about analysis. This is where our specialization comes in. In the first panel, we talked about specialization. The reason why Boach and I were able to pull off is to take advantage of our own specialization. But specialization is not for the sake of specialization. It's specialized to trade, or to collaborate in our case. And when you collaborate, good things happen using digital records.
Great. Irene?
Yeah, I'm very flattered to be here. Thank you for the invitation, especially as a PhD candidate among all these professors. I just want to say, well, as many have drawn attention to, the quantitative methods, or actually computational methods, really concern all levels of our research. So that is from corpus building, from the analysis and the interpretation of data, to the publication and presentation, which is a part that we often totally forget about, that is also increasingly digital. So when we talk about, the changes that computational methods, the digital, and yes, these are all different terms that, mean different things, but that we often conflate. Really, they touch upon all aspects of our scholarship. I have personally written in my essay about simply search algorithms, because it is one way to draw attention to the fact that we are all already engaging in, already using digital methods in our research, because I don't, the way we locate our corpora. But generally speaking, and it's really hard to give an overview over what can be done with computational methods, with quantitative methods. Generally speaking, they allow us to find patterns and, form clusters, so detect genres, find similarities between either texts, to do network analysis, for example. There's been work done in that direction, to try to establish topics, so that would be topic modeling, and to detect ruptures in consistency, kind of in stylistic consistency methods, for example. So there's really it's very, very broad, and that's just on the level of analysis what can be done. I really very frequently just draw attention to the fact that on the level of engaging with corpora, so that is just in kind of building our research corpora, we are all already engaging in digital methods, and on the level of presenting and publishing our research, we are all already increasingly digital. It is on the level of analysis that we still have a lot of work to do.
Great, thank you. Intisar?
Thank you for that. I would have had a cat face up here to say I am not a hirra or a qitta, but time doesn't permit. I say that because I wrote about Islamic legal canons as memes, and that obviously was one circulating a couple weeks back. And that would be, my idea is to sort of leverage the tools that are available computationally and that are growing in data science fields for approaches to Islamic legal history, and sort of using new tools for things like text mining or semantic search similarity, which someone mentioned previously. I think some of the good projects that I know about that are doing this sort of work and that are necessary preliminaries to doing it are the Kitab project out of Aga Khan University that Sarah Savant runs, which is looking at textual reuse, sort of big blocks of text. How are they used? How are they reused in other historical chronicles, say? And that requires looking at the being able to build an algorithm that can search for non-exact searches of these large blocks of text. And one thing that I have in mind is doing something similar for much smaller strings of text, these legal canons that kind of appear everywhere, but in a really unindexed way. And so I think the great value to using computational methods, and what some people are doing very well, is to be able to augment, not replace, but augment the research processes that we might individually generate, but could never possibly read through the millions or billions of words or pages of text to find these sorts of connections between texts of or sources of different types and the ideas within them.
Okay, thank you. Another question that I wanted to pose to our panelists is, what can we gain by blending these quantitative/digital methods with our traditional historical, textual, philological approaches to the study of Islamic legal history? How do you think these new technologies are impacting the field? How do you think they'll shape the future of the field? And if I can just add one more question is, for those of us who, we're interested in getting, getting started, but are intimidated, afraid, overwhelmed, don't know where to start, what advice would you give to students and scholars? So let's go with the same order, Boach, Metin, Irene, and then Intisar.
So we mentioned this in our piece. The collaboration part is really important. Collaboration of researchers who specialize on different forms of research, different areas of research, and who can come together, share their expertise, and ask questions that no one person can answer. And you see this very clearly, for example, when you have incredible amount of documents, just like the Ottomanists have from the court records. I mean, let's start with the most important question: what is justice, right? And there are different definitions of justice, and scholars have defined justice in the Ottoman context. But in terms of generating empirical research, how do you test hypotheses, right? Until very recently, the way to test hypotheses is to go find a court ledger that's composed of, for example, let's say 500 cases. Read that ledger from cover to cover, essentially, and take those kind of examples from inside and kind of weave them into a narrative of what you understand as justice, right? The problem about this is, as we know, is very anecdotal, right? And if you want to see certain patterns of adjudication, certain ways of administering justice, you have to do this repeatedly for thousands and thousands and thousands of documents. That's how this quantitative and computational methodologies could help you, right? If you can scan those documents, if you can run a regression analysis, right? By using all these observations, big data, you can in fact ask specific questions. Whether or not the answers that you get from those questions, help you to frame a conceptualization of justice is not clear, but you can get concrete answers to concrete questions, essentially. That's what these, quantitative and computational methodologies help you. The answer to your second question was given by other panelists as well. And this is very much actually interesting to Intisar's project too, and other people have been doing that, this topic modeling. See what kind of topics are there in large documents. For example, we are looking at Abu Suud's Fatawa, right? This is a monumental jurist from 16th century Ottoman Empire, right? But no one has read, very few people, I'm exaggerating, has read his corpus from cover to cover. So we know in general about what he talked about in his Fatawa, right? But how certain kind of areas of specialization are represented in it, nobody has an idea. Or people do have an idea, but they cannot definitively demonstrate, those masses of text, essentially. A topic modeling algorithm can help you map out, literally, map out different concentrations of interest. Now you have a concrete answer to a concrete question. What kind of themes occupied the mind of someone like Abu Suud Effendi?
Okay, thank you. Metin?
Thank you. So the way I understand your question, what do we gain by doing this? I think a lot of things, some that quickly come to mind are, one is efficiency. Especially in Islamic law, those of us who grew up bilingual, perhaps and here we are speaking English, we had that advantage, but others who did not have that lingual advantage, it was a huge obstacle for them to access the records. And digitization of these records and transcriptions of that makes that information available to the whole world, not just people around us. I think that's huge. What else do we gain? We gain new perspectives. And along with that, we gain new engagements with other disciplines, such as, again, myself, economists, sociologists, political scientists, other people from social sciences that I can speak about. And of course, there are many other scholars who can now, with those, at least there are some now commonalities that somebody else can just step in and look at a record and understand what's going on, especially if that can be done in collaboration with others. How is that impacting the field? I think the question obviously is not so much at this point whether we should engage this new developments in digital humanities, but how do we really do that? It's going to happen. It is happening, and the best way to think about, I think of it as an economist, and from the perspective of how I would go about analyzing it is, there is a huge development in social sciences, actually all sciences, in big data, and the same techniques that are developed in big data. It's basically, you're dealing with millions and millions of records, something like Facebook or whatever. Maybe our records are not that extensive, but still, if you're running some software to uncover some data that is hidden in there, nobody is going to be able to live long enough to read a whole corpus of documents, but the software can read it within seconds. And I think that's the way to go about, just learn that software, and more these software that are being used are accessible to others. A lot of universities, in fact, have people specialized in these softwares that are available to work with. And I would recommend doing it that way.
Okay, great. I'll just have to ask Irene and Intisar to give us an answer in 1 minute or less, briefly, if you can.
Okay, I'll be very quick. The new scale of available material is what excites most, but that has its own challenge. Nobody can read it all, especially as more and more becomes available. So there are two options: either be selective, and that's where my essay basically chimes in, how to be selective, or to use computational methods, because computers can read it all. And the next point is how to get started. Well, don't be scared. Programming is a language, and as humanists in our field, we are all very apt to study new languages and collaborate. You don't have to be a programmer. You just have to know how to talk to one. And that will be my very brief summary.
That's fantastic. Thank you. Intisar?
So I put something in the chat as to where to go for more information. We actually do a roundup, or the Islamic Law Blog does every week, on what's going on with data science. And on the contribution, I'd echo what the first two panelists said, and also just say something very concretely, because it came up before, and that's on the question of custom in Islamic law. Both for reasons that sort of using computational methods to help in reading thousands or tens of thousands of cases and historical records to find it can aid in, and because there is a famous legal canon on custom, al-'ada muhakkama. And in my view and my read of Islamic legal history and Islamic history more generally, custom is very much a part of the law well before the colonial period in many eras. But one doesn't need to take my word for it. I think to actually show and tell that requires the use of more folks working on it, and perhaps computational methods applied to it.
Okay, thank you. Just in the last minute, I actually wanted to go back to Ursilia, who's joining us from Naples, had some connectivity issues, and she has her essay on Ibadi law that we all wanted to hear about. So if I can ask you, Ursilia, to comment briefly on the Ibadi sources that you talk about in your essay, how accessible are they? Why do you think they've been neglected to date? And where do you see the future of the field of Ibadi studies going? And how can it contribute more broadly to Islamic legal history?
Hi, Mariam.
Yes, we can see you and we can hear you.
Sorry, but I cannot hear you. I'm sorry.
Oh, okay. Okay, no problem.
Okay, now I can hear you. Okay. First of all, thanks for inviting me to this very interesting webinar. I'm very sorry for all the problem I had with my connection, and I was not able, unfortunately, to follow the first two panels. I'm very sorry for that. Okay, just 1 minute statement about my contribution. Why it would be interesting or would be fundamental to include Ibadi law in the field of Islamic study and the field of Islamic law studies. Unfortunately, Ibadi law have been neglected up to now, but there is a big heritage of Ibadi literature available now, with a lot of new publication, new edition, and so on. And including Ibadism, as far as including Shia within the study of Ibadi law, Ibadi jurisprudence and law, will be a great contribution to the field, because we will give to the field a broader view on the development of Islamic law in general. Just two examples. Ibadi law preserve a lot of old traditions, not the canonical one, that can give us a picture of the development from the late antiquity to Islam. For example, I dealt with the question of zina and the impediment to marriage for people who committed zina, and this very interesting point in Ibadi law. Another example is in the late period is that for Ibadism, for example, the Bab al-Ijtihad was never closed. And it would be very interesting to see how Ibadi jurists articulated their argument in favor of the Ijtihad for the alim, even in the middle period. So I think studying Ibadi law within Islamic law in general would be a big contribution for all the field. Thank you, and sorry again for all the problem I had.
No problem. Thank you so much for joining us. So I'll turn it over to Intisar now.
Thank you all for your contributions and for the really rich discussion with, we were trying to be ambitious in having a broad-ranging conversation in a short amount of time, but this is not it. There is the blog itself, and I invite you all to, if you haven't, go read the contributions that all of the scholars here and more made to the blog, and their books and articles that the blog posts telegraph in some ways. So we will end here. We'll keep the room open for another 15 minutes for anyone who wants, and anyone on the panel who wants a sort of unmoderated discussion and audience questions from, or questions from the audience through the Q&A chat function. But the official event is over. Thank you very much. And we hope to see you all again in some sort of venue, virtual or in person soon.